Before we dive in, please note, this video provides general legal information. It is not formal legal advice. With the rollout of the European AI Act, there is a lingering assumption in the business world that a single, unified tech rulebook has arrived to replace older privacy laws. That is incorrect. Article 2, Paragraph 7 of the AI Act explicitly states that the two regimes coexist. A single AI operation processing user information is now subject to two massive regulatory frameworks simultaneously. For data protection officers and business leaders, this creates an immediate operational tension. You must execute the rigid safety protocols of the AI Act while upholding every data subject right granted by the GDPR without doubling your workload. To master compliance, you have to approach the AI Act as an overlay to the GDPR, rather than a replacement. Looking at this diagram, the left pane shows the specific lens of the AI Act. It regulates the technology system itself and its risks, classifying the businesses involved as either providers or deployers. On the right pane, we see the GDPR. This law protects personal data and the individual, categorizing the responsible businesses as controllers or processors. When we merge these halves, a single company will wear multiple hats across both frameworks at the exact same time for the exact same AI system. Fortunately, there is no gray area in the vocabulary. The AI Act borrows the exact definition of personal data directly from the GDPR. But the intersection between these laws gets complicated when we look at detecting bias in high-risk AI systems. To audit an algorithm for discrimination, developers often need to look at the very data points that reveal it. Article 10, Paragraph 5 of the AI Act explicitly allows companies to process special data categories, like health, racial origin, or religious beliefs, strictly to detect and correct bias. The GDPR tightly bounds this exception. This sensitive information must be handled under strict technical safeguards, and the data must be deleted immediately the moment the bias is corrected. Legally detecting AI bias requires a highly targeted, temporary suspension of GDPR data minimization rules, completely enveloped by GDPR privacy safeguards. Launching a high-risk AI system triggers another overlap, the dual impact assessment. This Venn diagram maps the required paperwork. On the left, we have the GDPR requirement, the Data Protection Impact Assessment, or DPIA, which focuses squarely on data risk and individual privacy. On the right is the AI Act requirement, the Fundamental Rights Impact Assessment, evaluating broader socioeconomic and systemic risks. That middle section represents a massive operational efficiency. Deployers can take the technical documentation supplied by the AI provider and use it to simultaneously feed both the DPIA and the FRIA, cutting the administrative burden in half. Beyond the paperwork, these two laws also collide over the actual mechanics of automated decision-making. The AI Act mandates active human oversight for high-risk systems to ensure algorithms are never operating completely unchecked. This directly supports Article 22 of the GDPR, which grants individuals the right not to be subjected to decisions based solely on automated processing. However, providing that oversight creates a technical conflict. The AI Act demands extensive traceability logs, meaning the system records its own actions. But if those logs capture personal information, individuals still hold their GDPR right to demand erasure. Technical compliance measures, like automatic logging, cannot be retrofitted. They must be structurally architected from day one to accommodate GDPR individual rights. Achieving this level of structural architecture requires a total internal shift. AI and GDPR compliance can no longer operate in isolated silos. They have to be treated as a single, unified corporate project. The data protection officer steps in as the central actor of AI compliance, mapping out every system that touches user data. But the DPO cannot work alone. They have to collaborate directly with business, security, and legal teams to cover all angles. Outside the company, the regulatory landscape is shifting in a similar direction. National data protection authorities are not stepping aside for newly created AI agencies. Instead, their roles are expanding. Looking at this map of Western Europe, we can see how this enforcement structure plays out. In France, the CNIL remains fully competent for data protection, while also stepping up as the market surveillance authority for 15 specific high-risk AI use cases, such as emotion recognition in the workplace. Shifting our focus to Belgium, we see a similar pattern. The National Data Protection Authority manages privacy rules, while simultaneously acting as the designated body protecting fundamental rights under the AI Act. For businesses, this dual-powered regulatory environment carries a silver lining. The hard work you have already put into GDPR compliance is not lost effort. It is the foundational requirement for safe AI deployment. AI compliance is simply the next evolution of data compliance. Mastering it demands an integrated governance approach to survive the scrutiny of today's dual-powered regulators.